Jersey City. My last question has to do with this fear of tribunals. The NDC government wants to reactivate the tribunal, the government of the day. It's in the constitution, but it looks as if it's not being used. It's 142. 142. Constitution is it. And I want to find out if it is legal, why do they have this fear? Thank you.
Mr. Chair, the honorable member asking me to assess why people have fear. Fortunately, I will not be able to find out why people have fear. The reality is that it's part of the law. It has not been used for some time now. It is being set up to deal with, we cannot shy away from the fact that we have delays in our system. Is it being brought to help clear this delay? Is it being brought to be given specific jurisdiction to deal with certain matters? I think it depends on what is the policy rationale in wanting to bring this. If that policy rationale is anchored in law, I do not think that anybody would be opposed to it. Thank you very much.
Thank you, my lord. I think it's coming to address the backlog and the delays. Thank you so much, and I wish you well. Congratulations.
Honorable Patrick Yaoboma, Senior, you have the floor.
Chairman, just to congratulate you, I don't have any question for you. I don't have any question for you. Congratulations. Thank you.
Thank you. Thank you very much.
Thank you. I'll proceed to give the floor to Honorable Haji Aladi Ayamba. You have the floor.
Thank you, Chairman. Congratulations, my lord. I have just two questions. One of them is about the retirement age of judges of the Court of Appeal and then the Supreme Court, which currently stands at 70. I have heard from certain quarters that we are thinking of 75. What is your opinion about it? And if you've heard it, that's if you are aware.
Thank you, Mr. Chair. I think I became aware through question of my other colleagues here. The reality is this. I think I do not have any statistics, but indication that people retire 70 and within a short time, they join the other side. The work of a judge is a stressful one. You burn the midnight oil, you sit up and write judgments. So I think that 70 is good enough. And let me say, even in other jurisdictions where they have 75, when you are about hitting 70, you can choose to be a supernumerary, which means that you've cut down your work, you choose what to do, and they'll rather give it to those who are young. So as my brother who once said here, I think the 70 is good enough. Let's stick to it. So that when we retire, we can have time to spend with family. Thank you.
Chairman, my second question is about our districts with courts and the lack of judges. I think this is about my third time of asking this same question. What is your suggestion on how we will be able to get judges to, I should say, the 216 or is it 17 districts as at now, so that we don't continue to delay cases, denying justice to people?
Thank you, Mr. Chair. I think the occupation of a judge work must be attractive. There are many lawyers who may desire to be judges, but if you join the bench and after 6 months you've not been paid because your name has not gone on the system, within that 6 months of your service, how are you supposed to support yourself? So let's make the job attractive. As we speak, my beloved Bogoso has a court yet to be inaugurated, and I'm sure the people there are yearning to have a judge. But if people are not willing to join the bench because the package is not attractive. Speak with those on the lower benches. Their situation is not the best. So let's make the job attractive, and I think we'll be able to have the best of the brains to join the bench for the benefit of our nation. Thank you.
Thank you, Mr. Chairman. I wish you all the best.
Honorable Jerry Ahmed, you have the floor.
Thank you, Chair. My Lord, congratulations to you, and you're welcome. My Lord, I've just perused Article 1461, and it talks about justice of the Supreme Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior. I'm not going to talk about or incompetence. I want, in your view, to tell me what would constitute stated misbehavior. If you have about 5 of those or less, it's fine.
Thank you, Mr. Chair. I think this is not defined clearly, but I think what is a misconduct, all of us, when we see one, we should see it. There is a Canadian case called Mary DeBow. What was deemed to be a misconduct was a judge sitting who became so frustrated with people who are in her court, and she made statement that they are lazy, they don't want to work, all they have to do is to engage in criminality. That statement was deemed a misconduct, and she was removed from the bench. Okay? I've been a member of an investigative body where a judge in the Upper East was sitting and didn't have a copy of the Minerals and Mining Law. A lawyer agreed that, my lord, when I get to Accra, I'll get you one. When the lawyer got the law, the mistake the lawyer made was, instead of taking it to the registrar, gave it to the client, and the client was going to give it to the judge. Somebody saw the person entering the judge's home, and a committee was set to investigate this as a misconduct. Of course, the committee eventually exonerated him, because we know that the litigant should not come to your home. So I think that many of the things that judges are required to do based on the ethics, if you go contrary to it, clearly may constitute a misconduct, depending on the facts to be determined.
Thank you very much, my Lord. So my understanding is that stated misbehavior depends, or misconduct depends on the facts to be determined. But these facts, as we have not seen the definition of stated misbehavior, in your view, what should we do about it? Should we define what stated misbehavior is?
I think at this stage, at this moment, Article 146 has become a topical issue. Maybe it's high time we have a CR or regulation, so some of these things can be properly defined, and everybody will know the parameters of what these are. Thank you.
My Lord, this also brings to mind, I know you are the kind of person who is very technologically inclined. I mean, I remember the last time I was before you was when you were in the High Court, and you had your own computers and things before you. So I labeled you as a gadget master. I want to find out, with the advancement of technology, the president is not in town, he's not in Ghana. The vice president is not in Ghana. The right honorable speaker is not in Ghana. At what stage would technology be beneficial to all the 3 that are not in Ghana? What would be your recommendation? Who is the president? Or who can be termed as the president?
I think, if I understand your question, if the president, for example, is in Geneva attending a UN program, and the vice president is here, can we clearly say that out of the jurisdiction based on technology now, the person is absent? I am of the view that if matters can be regulated from there, depending on the situation, because clearly the absence within the jurisdiction may not be the basis to say that the person is absent. I think we are looking at a situation where even judges, we should have a situation where a panel, one may be somewhere, if they can be linked up virtual to hear a matter, should be possible. So that's how I look at it. We can all take advantage of technology to answer some of these nuances. Thank you.
So would that be part of the recommendations you would pass on with reference to your issues on constitutional review?
Yes, I think some of these parameters must be clearly defined, and once they are distilled out plainly for everyone to understand that in such situations, the president or the vice president ought not to be deemed to have been absent and can still carry on his or her job, that will be very much welcome, so far as it has some statutory backing. Thank you.
Very excellent. My Lord, I just want to find out, how can the Supreme Court ensure some balancing with reference to, or in respect of, freedom of expression with the need to combat cybercrime and online misinformation?
I think in an earlier question, I quoted Lord Denning in British Steel Corporation. You know, I think free speech is not cheap. People should have the right to express themselves. But in expressing yourself, it should not be an avenue to abuse people and to defame people. We should recognize that online abuse is more serious than the old traditional way, because whatever you write here could be read in Australia or my made-up town of Ackaah. They will read it there, and it may be online, it will never go. So I think that once we want to allow people to have free speech, there must be responsibility attached to it. And so I believe in free speech, but free speech must be with some responsibility. Thank you.
Does that mean that people should be extremely careful as to what they say and when they say and where they say them?
I would say that social media has not done away with our old tort libel laws. They are still applicable. So that if you choose to go contrary to the law on social media, as I said, in Pakenham versus North Carolina, social media was deemed to be like you sitting at a public park and you uttering something. If that will be taken as serious, if you do it on social media, it should be taken as serious. Libel laws are still applicable. Let's be very careful about what we put on social media. If you go contrary, somebody ought to sue you. The court will hear that. Thank you.